Topless photos posted online as revenge. One Texas woman finding out some racy pictures she sent to a former boyfriend ended up on a porn site for the world to see. And she wasn't alone. She says she recognized more than a dozen other women on that website. And now they're suing the site, claiming the images were posted illegally and included information that made them easy to identify. Now, we're told there's been an increasing number of such lawsuits targeting so-called revenge porn, when pictures are posted by a jilted lover or even a computer repairman or a hacker who gets access to those photos. Doug Burns is joining us now. He's a criminal defense attorney and former prosecutor, along with Dan Shore, who is a former prosecutor and is the associate managing director at Kroll, a risk mitigation firm. Gentlemen, welcome. Great to have you here. Let's talk about this whole phenomenon known as revenge porn. Right now, they're saying they're seeing a lot more of this happening. And this woman is saying that she gave the photos to her former boyfriend and then found them on this porn site. And it was also linked to social media as well, which made her very upset that it was easy to identify. What do you make of this case?
Well, first of all, a lot of people, especially younger people, don't think about the consequences of allowing pictures or videos of themselves. Another person may have them and they could disseminate it later in the future, and there's no way to really stop that afterwards. She may have a good suit legally based on copyright infringement or invasion of privacy, but these sites are so shadowy, many of them are offshore, and it's hard to find who to sue and to successfully sue. And also, even if you can find who to sue, it's hard to stop it once it's out in the internet.
Also, it's difficult for law enforcement to pursue these cases as well. What about using emotional distress as a way to try and fight the case?
Well, no, you're 100% right, Uma. That's the, the actual tort, infliction of emotional distress. But working off of Dan's point, one, it may be hard to track them down as a practical matter. Two, the lawsuit's actually better, obviously, against the boyfriend who posted it than the site, it would seem to me. And then three, you have a point by analogy to libel litigation or defamation in general, which is that very often lawyers advise people not to pursue it because it's simply going to highlight it more. You follow me? So she initiates litigation, and next thing you know, it draws more attention and more people actually looking at the photos.
Does she really have a right to privacy, though, if she willingly gave those photographs to her former boyfriend?
She might have a good right to privacy on the internet to disseminate it publicly. Maybe it was given to the boyfriend for private use, and the internet site doesn't have the right to then publish it so everyone can see it around the world.
So now she's saying that this emotional distress, the fact that it's out on the social media sites, is a way to target her and these other women who are very angry and upset, and they want these sites shut down. But again, it's very difficult to track these sites once they're discovered.
Well, that's true. I mean, the internet, as Dan and I were discussing earlier, I mean, it's like this shadowy world of its own. And when you try to get down to the real world, like an office building, next thing you know, it's a post office box. And as you say, it's very hard to track.
What about the hosting factor? In fact, GoDaddy.com hosts this site, supposedly. They want to go after that hosting site as well. Do they have a claim here?
They may try to bring a suit, but it's going to be really difficult because these hosting sites have so many sites that have contracts with them, and to find them responsible for it would be a real stretch, in my opinion.
All right, moving now to another story that's been making some news as well. A former North Carolina teacher charged with having sex with a student used an interesting tactic to avoid jail time. 42-year-old Leah Gail Shipman was charged back in 2009 for statutory rape and taking indecent liberties with a student. And after that incident last month, she pleaded guilty to a misdemeanor. She avoids jail time because since that incident, she married the victim. Now, state law says statements about the sexual encounters are inadmissible if the spouse does not agree to testify. So this was a very clever little tactic that she used. And right now they're trying to also determine whether or not this particular situation dates back to when they were actually engaged, to see if she can still hold on to this claim.
It's unfortunate. I'm a former sex crimes prosecutor, and very often when you see the teacher being the female, here she was around 40, and the student being 15, people don't take it as seriously as when there's a male teacher and a female student, yet these should be vigorously prosecuted. She's still a sexual predator, and unfortunately it looks like she's getting away with doing this with just probation.
And we all know the story of Mary Kay Letourneau, of course, the very famous story where she was involved with her student. How does this differ?
Well, no, it's interesting. I mean, it depends on what your moral lens and your moral compass is. I mean, on the one hand, you can be very cynical and say they're a sexual predator, and I don't disagree. But then when subsequent events turn out that they end up getting married, you know, having a family, having children, then you can turn around and argue, you know, this was a true love and so on and so forth. Here, this gets a little confusing legally, though, because just because they get married doesn't necessarily mean that retroactively the marital privilege goes back to the time of the events, and theoretically one could testify about that. I think what was posted on the screen was very helpful, which is that you need the willingness of the spouse to testify. It's really independent of the privilege, then, is the point?
And one really important point is these types of cases don't have physical evidence because they usually aren't forcible rapes, they're statutory rapes, and it's really hard to prosecute them without a willing victim. And here, with or without the privilege, it's hard to get someone to testify against their spouse in a way that's going to make out the crime.
Very interesting. Gentlemen, thank you so much for joining us with your insights. We appreciate it.
Thank you.
Thanks.
Welcome back, everybody. Well, right now, the popular dating website Match.com is getting ready for a big battle in court. A former customer is suing, saying the company gives users a false sense of security when they go out with people they meet on that site. Mary Kay Beckman went out on a few dates with someone she met there, but it didn't feel right, so she called it off. Well, that man, Wade Ridley, then went to her house and ambushed her, stabbing her, stomping her, and smashing her face with a rock. She nearly died. A month later, he killed an Arizona woman he also met on that site.
He broke into my garage, and when the police arrested him, he said, "I was not there to hurt her, I was there to kill her." And so his intent was to kill me that night.
That's a very traumatic thing for anybody to have to go through.
I struggled a lot thinking,
why did she die and why did I live?
they don't say that 1 in 5 are part of an attempted murder or 1 in 5 are killed. They don't tell you that people are missing.
God saved me that night for a reason. I should not be here today. If I can save somebody from being hurt or making a different decision with their online dating choices, that's my mission and my goal.
This is a tragic story, and our legal panel is joining us once again. Doug Burns, a criminal defense attorney and former prosecutor, along with Dan Shore, former prosecutor and the associate managing director at Kroll. Well, gentlemen, this is a very scary story indeed, something that no one would want to go through. And of course, Match.com will say that they have lots of success stories. Will use their site with no problems, and yet this woman is saying, I want that company to have some kind of disclaimer that puts it out there that you could be harmed if you do go forward and go out with someone from the site.
This is a tragic case. You have this victim who is brutalized. You have another woman who is actually murdered. The defendant here was convicted of murder and died in prison. The question here is, was there a duty on the part of Match.com to perform some kind of background check? And even if they did, this defendant didn't have a criminal record, so it's unclear what they could have found in a background check. However, maybe there should be more of a warning so people know about the dangers, which happen no matter who you're meeting if they're a stranger.
But even if you do a background check and that person checks out, there's no guarantee, like in this case, of that person not doing harm to you.
I mean, from a legal perspective, honestly, you can't protect against unforeseen, intense criminal conduct that just comes up out of nowhere. I mean, theoretically, you could meet and vet, so to speak, somebody socially in whatever context, a party, a bar, a get-together, go out with them a couple of times, and the next thing you know, they show up and engage in horrific criminal conduct. So I agree with Dan. I mean, I think it's very hard. I mean, technically she has a point, which is you should put up there that this is at your own risk to some extent, and we haven't conducted a check. That might lead people to take it upon themselves to do that. But again, overall, I think the liability landscape's a little tricky and potentially difficult.
I think a lot of people, though, do have a false sense of security because they're paying to be on that site. So they have a level of expectancy to believe that these people that are being advertised out there, so to speak, are some people that you can trust.
Right, it's important to know that not just on Match.com, but all these dating sites, people generally are not vetted by the site, and therefore they could be lying about who they are, or they could be who they are, but not all of their past history is revealed. And in this case, the defendant did not have a criminal record, so it's hard to know what they could have warned about, except in general, maybe there should be more warnings about people going on a site and meeting strangers saying these people may be dangerous.
Indeed. All right, now to another safety-related lawsuit, and this one is against the NFL and the official helmet maker for the league. The family of star linebacker Junior Seau says the defendants were hiding information that links suicide and head injuries, like the kind football players suffer from. Seau killed himself last year by shooting himself in the chest. Now, this particular lawsuit raises some big concerns. From your vantage point, how do you see this?
Well, first you mentioned the helmet maker, Riddell, and a lot of experts that I saw saying, they said that Riddell's been very successful in the sense that the helmet is designed and does what it's supposed to do, and that there's been very little success against them. Now you talk about against the league. It's interesting. The lawsuit was brought in San Diego, and they engaged in what we call removal. The defendant has the option to remove it into federal court, and they did that. And there are something like 3,800 similar cases, all before a particular judge in federal court in Philadelphia. Now, on the merits of the claim, it's a tragic case. Obviously, he committed suicide, and not to appear callous on any level, though. I mean, there's a tremendous assumption of tremendous risk playing NFL football, number one, and then number two, there's a huge scientific battle about did that link or cause him to commit suicide.
Now, how do you draw that link? How do you determine that link?
Right.
Well, the link is one part of it, and that would have to be based on scientific testimony. The other part of it is what people knew and when they knew it. The NFL has taken a lot of steps recently to stop head injuries. They've changed the rules about helmet-to-helmet contact.
Right.
People aren't put back in the game immediately, if they might have a head injury. So there are a lot of steps to protect players now. The question is, as Doug said, what kind of assumption of risk is there, and is there then a claim against the NFL?
It was a very provocative case indeed. Gentlemen, thank you so much for joining us again with your insights. There's a lot of stories making news right now.
Thank you.
All right,
My
thanks.
pleasure.